Folks, quiet, please. What is this session? Maybe see.
In the matter of Lindsey Gaetani versus Aidan Kearney. Would both parties stand and raise their right hands? Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right. So we are here regarding an extension of restraining order hearing. Ms. Lindsey Gaetani. I will give you this opportunity. I have read your affidavit. Is everything in that affidavit true and accurate?
I don't believe I submitted an affidavit.
Well, you submitted an affidavit originally with.
Oh, the
order.
first one.
Yes.
Okay, yes.
Okay. And additionally, at this time, what I'll do, because I know you're not represented by counsel, I'll give you an opportunity to give a narrative, meaning you can tell me in your own words what you'd like to tell me for my consideration for purposes of extending the order. Counsel, then I'll give you an opportunity to cross-examine the plaintiff. And do you have any other witnesses you'll be calling now?
No.
Okay. All right. So whenever you're ready, you may proceed.
Thank you, Your Honor.
Good morning, Your Honor. I'm here respectfully to ask that my restraining order be renewed. I received a copy of the defendant's statement late yesterday afternoon, and I was able to review that. While I wholly disagree with most of the statement, I do realize we're not here to relitigate the original order, and rather for me to explain to you why I remain in fear of the defendant. So I first want to just express that the order is, my children are covered under the order as well. I remain in constant imminent fear every day of the defendant. I am very scared about potential future physical risk as well. To begin, the order was violated in February of 2024 during a hearing actually across the street at the Superior Court, which I and the attendant both attended. He did leave the courtroom, but he remained outside afterwards and essentially followed me to my car, taking pictures and videos of me as I walked with the group of people I was with, well within the 100 yards of the order. And I had no way to get to my car other than passing by him as he moved from spot to spot, following me all the way to my car or to the entrance to the parking lot. My car was vandalized that day.
Hold on one second. Sir, are you a member of the media?
Your Honor.
Folks, quiet, please.
Did he ask permission to?
Not today, not to my knowledge.
Are you going to have to put that video camera away? You did not request permission prior to the hearing. All right, you may proceed.
Thank you.
So the defendant was charged with a violation that is still a pending matter. It still has not been, we haven't gone to trial for that yet. So that is one of the reasons. Another, he was indicted for witness intimidation and wiretapping against me, and those matters are still pending as well at the Superior Court. We have not gone to trial for those either. And I'm very much in fear of what he may do in regards to the result of the cases, because he's also facing numerous other charges against many other witnesses and facing many, many years in prison. So I am very scared of what him getting in a desperate state, what he may do to try to prevent me from speaking, as he's already tried to do in the past. You know, he has expressed to me in the past and on his, so I should mention, I think it was in my original affidavit, he is a well-known blogger and YouTuber and has a very large following of fans. He gets tens of thousands, hundreds of thousands of views on his YouTube page and social media platforms. He has announced to me and on his YouTube shows in the past that he struggles with mental health issues. He has told me specifically that hears voices, has thoughts of suicide, that like he has suffered with this in the past, and I'm afraid what he might do if he was put in a desperate position facing all these years in prison. He has engaged in a year-long smear campaign against me, using his platforms publicly, even while he was in jail, writing blogs about me filled with disparaging lies from jail, posting my picture, private court documents, he posted police reports where he doxed my full name, address, phone number, birth date, and that has resulted in his followers, like he has like incited them to harass me as well. They've gotten death threats. I've gotten calls to the Board of Nursing to try to get my nursing license suspended, calls to my children's school and emails to their school, constant calls to DCF with false reports. May I look at my notes? Just, he was given by accident in April of 2024 a full forensic unredacted copy of my cell phone, which I had given to the Mass State Police because I was a witness for a matter that he was involved in prior to me. And it was handed to him by mistake, and he has been sharing it, announced on his show. Like, I was alerted to this by a friend back when it happened in April. He went live on his YouTube show and announced that he'd received this copy of my 15 years of my life, everything you could imagine, from medical records to attorney communications, picture, intimate pictures, everything, medical, bank records, everything. And he announced that he had already shared it with dozens and dozens of people, and he has continued to share information from my phone since that day that he got it, despite numerous protective orders with the courts at the Superior Court, and despite assurances from his attorney that he would not do so anymore. Recently, Judge 𝗄𝗏 at the Superior Court put in place a more stringent protective order, basically ordering him to give back the phone extraction and any and all copies, and stop sharing any information from my phone. But the damage has been done. He, mere days later after that order was put in place, he went on his show again and announced that the order was essentially useless because he shared it with so many people he can't even remember how many people he shared it with. And who's to stop somebody from an anonymous account or another country from sharing information? On one of his shows, he declared that when his trial is all over, he'll release the really good stuff. He has told his viewers that I conspired with the Mass State Police and Norfolk County District Attorney's Office to set him up, that this was all a big setup, and that nothing related to the charges ever happened, that it was all lies. And he refers to me and asked his viewers to refer to me as fake victim. So it has resulted in harassment from all of his fans everywhere. Like, I can't even come into the courthouse without being harassed on my way in, because he's convinced these people that I have lied about abuse, that I've lied about these allegations, and that I'm a fake victim. I received a phone call, a disturbing phone call in, I think it was August of 2024, from a number I didn't recognize. And I answered it, and it was late at night, and it was it sounded like a voice changer the voice sounded robotic. And they asked me where my daughter was and named her. She's 3 years old. And they said that they had a present for her. And then they started singing Ring Around the Rosie and hung up the phone. And I was later informed that the phone number is a number registered to Mr. Kearney. And
how did you learn that?
A friend alerted me, because I told a friend that I got this call, and I shared the number, and they Googled it, and it shows that the number is registered to him, and that I guess he has two numbers, and his main number is the one that I had, but this is his backup secondary number. So it shows, I submitted evidence to Attorney Bradl, which I can give to you as well. It shows the Google search returns his name and address as the owner of the phone.
Attorney Bradl, you've seen that?
I have you on.
So just the whole packet. It's the first 3 pages.
Judge, just for the record, I would object to any evidence that doesn't is material or relevant to the plaintiff's reasonable fear of imminent serious bodily harm. This is a 209A order. There's no right to get a restraining order out of fear of being disparaged online. So to the extent that anything in there just refers to disparagement or complaining about someone's conduct, I would object. Thank you.
Thank you. I haven't made my ruling yet. Let me read the material, and I'll let you know what my ruling is. Plaintiff and counsel on that.
Once again, all phones should be turned off, okay?
It's really before me at the moment. You provided me with a packet of material, but what you're at least initially trying to move in is the phone number check. Is that correct?
Correct.
Okay. And I've heard your testimony regarding that. This phone number check is not authenticated. It's not a phone record, but I have heard your testimony on it. So as far as the phone record check, that will mark that A for identification, but that will not be permitted into evidence. So
Yes,
also your objection is sustained. Do you want to move these other items in as well?
Yes, Your Honor. I've only provided just a few examples of some posts on social media and blogs that he has put up regarding me. These are, when I say only a few, I mean, he does 3 YouTube shows a week that are at least 3 hours long each, and has been talking about me daily for the past year. So, and then has multiple social media platforms where he's posted about me hundreds of times, if not thousands. So I couldn't possibly submit everything to you. These are just a few examples. And I do want to say that the phone call, if that, I don't know if that specifically is what Attorney Bradl was referring to in the evidence I submitted, but it does directly relate to my fear of physical harm of the plaintiff. I took my children immediately the next morning, packed our bags and left our home because I was too scared to stay there. We went down to a private resort on the Cape, and when we left several days later, there was pictures posted on social media of my children and I on the beach. I can't leave my home without being harassed by his followers.
1 second, ma'am. I just want to rule appropriately on your evidence. So I have another packet of items that appear to be emails from Aidan Kearney, the defendant, or I should say postings by Aidan Kearney, the defendant, referencing you. There's a packet of them. Totals 11 pages. Again, counsel, I heard your objection to all of these items. As far as these items go, is there anything else you'd like to add?
Judge, just that there's they lack materiality in the sense that there's no nothing germane to the standard that we're here to evaluate.
Okay. All right. So these items, collectively 11 pages, are admissible as exhibit number 1.
Thank
So
you,
those will
Anna.
come in.
And exhibit 1.
And then there was an additional item or a series of documents that were posts from other individuals, not Aidan Kearney. And those remaining items, the objection is sustained regarding those items. And those will not come in. Those will be marked as exhibit B for identification.
Thank you, Ron.
All right, you may continue.
So, I mean, even with so there was a modification to the order in April 2024, which allowed the defendant to be within 50 yards of me of any courthouse in Massachusetts. And even with just that slight modification, it's allowed the defendant the ability to abuse it and harass me. On one occasion, he sent one of his fans into the courtroom to take a picture of me at a probate matter regarding my children, and posted it from one of his they call it a stock account, like an account, like a fake Twitter account, basically. On another occasion, just recently, about 2 weeks ago on Christmas
Let me
Eve.
ask you a quick question about that. How do you know that he sent the individual in? Did that individual tell you, or did you learn from some other source?
It was, she told somebody that told somebody that he's, so it would be hearsay, but she was there with the father of my children, who the defendant has publicly stated on his YouTube shows that he reached out to, who I have a restraining order against as well after leaving a 6-year abusive relationship with him. And he has colluded with the father of my children to engage in more harassment against
Objection,
me.
Your Honor. Motion to strike.
If you still have more testimony, I'm happy to hear it, but that objection is sustained.
So recently, it's 2 weeks ago, December 24th, I was in court for another matter, completely unrelated to the defendant, and he attended, I believe, just as a way to intimidate me, and sat in the back of the courtroom, looked over at me and smiled and winked. And I
When
just,
was that?
what was that?
When was that?
December 24th, just a couple weeks ago.
Okay.
He had no reason to be at that court matter, and he announced on his show actually that he was not there as a reporter. And so I feel as though he's using this slight modification just as a way to continue to keep tabs on me and follow me to places where I'm going.
Objection, Your Honor. That assumes facts, not evidence. She's never been followed anywhere.
Anything else, ma'am?
Each and every time, even like we just have a hearing like today, he obtains the video and audio and posts it on his YouTube show and sits and harasses. And I mean, he's made threats. He's told me on his YouTube show, he's talked directly to me at certain points, which I reported to the Medfield police. They did not violate him for that. But he has said that I'm gonna get mine. He has said that like karma always comes around. She better watch out. He has the day that he violated the restraining order, I think it was that morning, I later saw a clip of his show where he said that you know, it wouldn't be smart of her to show up here. She better not, you know, something along the lines of like, you guys know what will happen. And he blows this dog whistle with his fans, and I'm terrified every day. Like I'm afraid to leave my house. I don't know what he's capable of and what he could or would do. There has been other people that have tried to get orders on him that were not successful in getting orders, and then
Objection to relevance, Your Honor. Motion to strike.
well,
Motion to strike is allowed.
and then he has showed up to where they work and live and tried to harass them. So I am extremely fearful that if this order is not renewed, he will use that same opportunity with me and show up to my children's schools, to my home, to where I am. And he says in his affidavit that the order prevents him from being able to travel freely and has something about his First Amendment rights. And that is completely false. I live in Medfield. I live nowhere near him. He has no reason to travel to my town. I don't go to anywhere that he goes. I don't want anything to do with him. I just want to be left alone. And I'm extremely fearful of what he might do. And if this order doesn't get renewed, I'm very, very scared about the lengths he will go to get revenge on me, as he has stated he will not go back to jail under any circumstances. And so respectfully, Your Honor, I ask that this order be renewed for as long as possible, for at least a year. But
Thank you very much, ma'am. One question though. You said you were afraid that he'll go to your children's school. Has he ever gone to your children's school?
no, Your Honor, but he's well, their school has received numerous calls and emails from anonymous accounts with sexual text messages between me and the defendant that only he had, and references to his case.
From who?
It's from anonymous accounts.
All right. Thank you very much, ma'am. Counsel, do you have any questions for the plaintiff?
Yes, I do, Your Honor. Ma'am, that you said a couple of times here that you're scared of Mr. Kearney every single day. You're terrified. You seem like you're trembling. You're crying. You're having a rough time, right?
Yes.
On October 15th, 2024, you sent a tweet basically proclaiming that you're not scared of him, didn't you?
I'd have to see the tweet.
May I?
You may.
So my question to you, ma'am, is you sent that
I'm so-
tweet, correct?
I'm sorry, I'm still reading. It doesn't say, I don't say
Okay,
that
there's
I'm,
no question.
There's no question before you, ma'am. Look up when you're done reading the
Okay.
text.
You've read the text?
Yes,
You sent that tweet rather, right? You sent that tweet, correct?
I posted this.
You posted it. Thank you. I'll take that from you. Offer this judge as next exhibit.
I would object to the there's no context.
So objecting to the context. Your objection is noted, but overruled. This will be entered as exhibit 2.
Exhibit 2 entered.
Now, ma'am, you testified about a phone call that you say was made by Mr. Kearney from a 413 number on August 22nd, 2024, correct?
Correct.
And it sounds like a horrible incident. 46 seconds, taunting about presents for your kids, using a voice changer. It sounds really pretty evil and insidious, right?
Yes,
And so I presume that you called 911 after that?
I called the police.
And did you make a police report?
I did. They came to my home.
Do you have it?
Not
Did you bring it to offer to the court?
no,
Ma'am, the fact is, this is a fake phone record, isn't that true?
no.
So you don't have any documentation of anything that you say happened here to offer the court today, correct?
I don't understand the question.
Just your word. You just have your word. You don't have any police reports. You don't have any recordings. You don't have anything, do you?
I didn't bring them. No.
Now, you also offered the court a stack of internet postings, some of which are from Mr. Kearney, some of which that were not admitted into evidence are from other people, right?
Correct.
Now, do you have a copy of your exhibit?
Yes, I do.
Can you look through there and just show me where there's any sort of threat to do bodily harm or property damage? Take all the time you need.
I don't think there's any threats about property damage in these.
What about bodily harm? Is there anything, I'm going to choke you, I'm going to get you, I'm going to beat you, I'm going to strangle you, I'm going to do anything to you, such as that?
No, not that I see.
Judge, I'd strike the exhibit for materiality relevance, given that this is a 209A order. There's nothing in there whatsoever beyond a general fear of disparagement, which I would contend is not sufficient.
It's still potentially relevant for coercion purposes, so your motion to strike is denied.
Thank you. Respect, Your Honor, only. Judge, just one moment, please, Your Honor. Now, the basis for this order a year ago was an incident that happened at your house on December 23rd of 2023, correct?
Correct.
And it's fair to say that the allegation of physical harm in that case was that you had taken some personal property of Mr. Kearney, some notes, stuffed them in your shirt or hid them in your mattress, depending on what document you consult that you wrote or caused to be written. And that in some sort of struggle to get those papers back, you fell down to the couch. Is that right?
No, that's not correct.
Well, isn't that what you told the police, that you were pushed down onto the couch?
I told the police that I was grabbed by the wrist and the arm and then pushed onto the couch. You just asked me if I fell onto the couch, and that's not correct. I did
All
not
right,
fall.
so you were pushed onto the couch by Mr. Kearney. That was the extent of the physical contact that was alleged by you, correct?
From that night, correct.
And that was the basis for the assault and battery charge that was brought, and that you then based your application for a restraining order on, correct?
That and the threats, the witness intimidation.
Threats and witness intimidation. But in terms of bodily harm, the only bodily harm that you've alleged is this being pushed on the couch allegation, right?
And also the grabbing of my arms, yes.
And you've since recanted that twice, haven't you?
No, I have
You
not.
said to Grace Barrett that it never happened. Isn't that right?
That's completely false.
And you also, do you know Mary Bagwell?
Yes, I do.
How do you know Mary Bagwell?
She used to be in a group chat that I was in with some other people who believed that Karen Reed was guilty.
Isn't it true that you told Mary Bagwell, your former friend, that getting pushed onto the couch by Mr. Kearney never happened? And when Ms. Bagwell told you that you need to do the right thing and tell the truth, you said, no, you're stuck with it because the police are pressuring you and you can't take it back. Isn't that right?
Completely false.
Was that before or after you threatened to murder her and her children?
I just told you that was false.
Did you threaten to murder her and her children?
Your Honor, I would object because this has no relevancy to this case.
Objection is overruled. Please answer the question.
Your Honor, I'd like to, this is a pending matter, so I don't know if I have a privilege here, a Fifth Amendment privilege to invoke. Mr. Kearney claimed in his affidavit that I am going to be getting criminal charges against me, but I have not received anything yet. So
So what we'll do is I'll step this matter back. I'll give you an opportunity I'll appoint an attorney. I'll give you an opportunity to speak with that attorney. And then we'll proceed accordingly after I hear from the attorney.
For the call. Thank you for the call.
Thank you very much.
Court, all rise. This court stands in a recess, please go in the hallway. Thank you.
What's that?
Mary, okay, so she's got Mary Bagwell and Aidan Kearney.
Yes.
Okay. Good.
On the record in the matter of Gaetani versus Kearney.
All right, so we stepped this matter back so that Ms. Gaetani could speak with counsel regarding a potential fifth regarding one of the questions that was asked of her from Attorney Bradl. Counsel, if you could identify yourself for the record and then report to the court, please.
Thank you, Your Honor. My name is Attorney Kevin Morales. I spoke with Ms. Lindsey Gaetani, and she did go over everything with me. I would report to the court that she does have a Fifth Amendment issue, Your Honor.
Okay, thank you very much, Attorney Morales.
Thank you.
So Attorney Bradl, what I'm inclined to do, and I'll hear your input
Thank you.
and your position, but what I'm inclined to do is I'm not going to compel the plaintiff to testify regarding that question,
Thank you, Your Honor.
but I'm not going to bar further inquiry. So you may ask other questions and you may continue with your cross-examination.
Thank you very much, Your Honor. I asked the court.
But before we go on, I'd also give you an opportunity to make an offer of proof of what you think her response will be.
Yes, thank you, Your Honor. The plaintiff struck a friendship with one of our witnesses today, Ms. Mary Bagwell, and they had a commonality surrounding the Karen Reed murder trial across the street, wherein they were both sort of anti-Karen Reed, pro-conviction protesters. So in other words, just for clarity's sake, taking a position opposite of my client. So Ms. Bagwell is on the other side, so to speak, on that case. She's not someone that's any sort of follower or puppet or anything on our side of anything. And they struck up a friendship. And Ms. Bagwell took issue with some things that Ms. Gaetani did with her children, driving while intoxicated with her children, and talked about that. And in the course of that friendship, Ms. Gaetani, this is our offer of proof that Ms. Bagwell will testify to, that
That's not what I'm asking. What I'm
I'm
asking
sorry.
is for an offer of proof regarding what you believe the plaintiff's response would have been. to the
a truthful
question.
response, Judge, would be that she called Ms. Bagwell, and I'll give you the background later. I'm sorry, I didn't quite understand your question. She called Ms. Bagwell and threatened to murder her and her children. And I have a tape recording of it that I would offer as well. And I'd like to play that as a part of my offer of proof, if I may.
I would like to object to that, Your Honor.
Well, it's being played as an offer of proof at this point. Your objection is noted. I'm not accepting it as evidence. Just permitting him to make a record regarding testimony that thus far I have not required him to respond regarding.
May I just make a comment? Because the recording was taken without my knowledge, and I don't know the relevancy as well. So.
Well, thank you for that. You may continue with your offer of proof.
Thank you, Your Honor.
You are crying about my kids on an internet chat on the
So Ms. Bagwell, we intend to call her to authenticate that tape and testify that that's Ms. Gaetani. So it's the third, if not more than the third time that Ms. Bagwell was threatened by Ms. Gaetani, resulting in Ms. Bagwell going to the Attleboro District Court and obtaining an order of a criminal harassment order, Your Honor, against Ms. Gaetani, which is pending. And there's also an upcoming criminal complaint for threats against Ms. Gaetani.
So your offer of proof is noted, and again, that is not coming in as evidence at this time. Madam Plaintiff, counsel, you may continue your inquiry regarding cross-examination.
Thank you, Judge. And this certainly isn't, Your Honor is the fact finder, and I'm not looking for a response to this, but I would invite the court as the fact finder to make a negative inference due to the invocation of the Fifth Amendment privilege in a civil matter.
Okay, I am not going to do that, so your request is denied. But I'll certainly hear any testimony, and I'll certainly hear any arguments later regarding the admissible evidence.
Thank you very much, Your Honor. So, Ms. Gaetani, you know Mary Bagwell, correct?
Correct.
And how did you meet Ms. Bagwell?
I met her at a protest at Karen Reed trial.
And you got to be very friendly with her, correct?
Yeah, I'd say we were cordial.
You shared your domestic violence history, and she shared her history as well. Is that right?
I didn't share much of my history with him.
You met her about June of 2024. Is that right?
I would say so.
On that date, on actually June 1st, 2024, you also were protesting with Ms. Bagwell at the Karen Reed case, correct?
I don't remember the exact date.
So it's fair to say on a couple of occasions you were with Ms. Bagwell when the Karen Reed case was going on across the street, correct?
I believe it was twice, yes.
And one time you saw Mr. Kearney in the vicinity in June, correct?
No, not correct.
Well, you spoke with Ms. Bagwell about allegedly Aidan showing up. Isn't that right?
Yes.
And that's about the time when you were very angry that the state police had provided your phone extraction to the defense in the criminal matters that you're involved with regarding Mr. Kearney, right?
I believe that was several months later.
Well, you were mad that you felt like you were lied to by the police, that only parts of your phone were going to go to the defense, but the entire phone went to the defense, right?
Correct.
And you said to Ms. Bagwell that if you had known that, you would have never agreed to cooperate with them and give them your phone, right?
I said I would have never given my phone. I didn't say I wouldn't have cooperated.
And Mary Bagwell was trying to be sympathetic. She said to you that she was sorry that you were going through this, but don't worry, everything's going to be okay, right?
I don't recall what her responses were.
And you got upset. You said, no, it won't be okay. My kid's birth records, school records, doctor contacts are all stuff he now has. You said that to Mary, right?
I don't recall this conversation.
So back to Ms. Bagwell. You related part of that night to Ms. Bagwell, didn't you?
Attorney Bradl, I've told you
Yes or no?
multiple times I never had this conversation with Mary Bagwell.
You told Mary Bagwell that Aidan Kearney did not push you on the couch or assault you. Isn't that correct?
Did not. No, that is not correct.
You said to Mary that he was just grabbing at the papers. Isn't that right?
No.
Mary told you to do the right thing and tell the truth, didn't she?
No, she didn't.
You were screaming and crying at her. She felt bad for you and gave you a tissue, didn't she?
No, it's never happened.
You felt badly for what you did, and you expressed that to Ms. Bagwell, didn't you?
Nope, I never did.
So then, as July goes on, Ms. Bagwell expressed concerns to you about your parenting and your drinking, did she not?
No, she never did.
She never did. That was in the summer of 2024, wasn't it?
Never happened.
You started to get annoyed with Ms. Bagwell. You started calling her a bitch, tell her to worry about her own fucking kids, and that she had better stop talking, and that she didn't know who she was fucking with. and that you said initially that I will come to your house and beat your ass in front of your kid. Right.
Stop. Do not answer that question. That was the Fifth Amendment issue, counsel. Do not go there.
In December of 2024, so just this past month, you called Ms. Bagwell 8 times from a blocked number, correct?
No,
Didn't you admit to the Attleboro Court judge that you did so?
it was 4 times.
So you admitted to doing it 4 times to the Attleboro judge?
Yes.
And Judge, just to point out, before Ms. Gaetani answers, my next question would be, you also admitted to the North Attleboro judge that you called Ms. Bagwell and threatened to murder her and her children, come to the house and murder her and her children. And that there's an admission in the court record in Attleboro. That's my question.
I appreciate you presenting that to the court first. And you may not have that question, counsel, but you may proceed with your.
Thank you. And just in terms of an offer of proof, I would contend, Judge, that that's my information from my witness, and that I would make an offer of proof, and I'd make a legal argument, Judge, that Ms. Gaetani has waived her Fifth Amendment privilege relative to this transaction by testifying to it in the Attleboro court. Just my legal argument.
Your offer of proof and your argument is noted, but overruled at this time insofar as being permitted to ask that question.
Thank you, Madam Chair. Now, ma'am, you talked about the pending violation of a restraining order case in this court. You recall talking to the judge about that? Judge Clifford, here today
The pending restraining order case with who?
with Mr. Kearney. You spoke to Judge Clifford about that today, correct?
Correct.
And that was on 2/26/24, correct?
I'm confused.
On 2/26/24, you were
The
at,
violation. I'm sorry, I didn't mean to interrupt.
that's okay. You were, all right, let's rewind a little bit. There's a pending violation of a restraining order case in this court, correct?
Yes, correct.
And that was on 2/26/24, resulting from you coming out of a Karen Reed murder case hearing, claiming that Mr. Kearney was violating the order against you, right?
Correct.
Remember you told Judge Clifford about that, right?
Yes.
You said something to the effect that you were concerned that you couldn't get to your car because he was sort of blocking the way, or something to that effect, right?
Something that I was forced to walk down as he followed.
And you told the police that he was screaming at you, liar, liar, correct?
Yes.
And you implied or said to the police that you perceived that and experienced emotional distress from that and fear, right?
I don't remember what my exact words.
I'm not asking you for your words. I'm asking if you remember what your emotions were at the time. Fear and emotional distress, right?
After the hearing?
Yeah, when you said this thing happened.
Yes.
So isn't it true that you had no perception or realization that Mr. Kearney was anywhere near you when you came out of that courthouse?
No, that's not true.
That's not true. All right, let's go through it. So you get out of there. It was a quick hearing that day, right? It was about a 10-minute hearing and you were out of there at about 2:10 p.m., right?
Should I answer these questions where we still have not gone to trial for this matter?
Ma'am, please answer the question.
Okay. Can you repeat it, please?
You got out of the Karen Reed case that day on 2/26/24 at about 2:10 or 2:15 p.m., right?
I don't remember the
You
time.
remember the day. It was a quick hearing,
I
right?
remember the day, but I don't remember the time.
You came into that courtroom and you were acting like as a human shield to kick Mr. Kearney out of there, weren't you?
No.
You stoked up a friendship with people that are antagonistic to him, and they brought you to court that day to kick Mr. Kearney out with that restraining order, right?
No.
Well, you walked into that courtroom at about 2 o'clock with the restraining order copy in your hand, didn't you?
I walked into the courthouse, and when I went through security, well, before I went in the courthouse, a member from the group called ahead to let them know there was a potential that
My question was that you went into the courtroom with the restraining order in your hand, correct?
I was told to have it out and ready. Yes.
So it's a yes.
Yes.
You went in there, you knew Mr. Kearney was already in there, performing his job as a journalist, covering the Karen Reed trial, correct?
I didn't know.
You knew he was in there, didn't you?
I knew there was a potential he could be in there.
Mr. Kearney had publicly announced that he was going to the Karen Reed case that day, and you knew about it. Isn't that right?
No.
You went in there with the restraining order in your hand to flush Mr. Kearney out of that courtroom at the behest of all the people on the prosecution side of that case to exact revenge on Mr. Kearney. Isn't that right?
No, that's not right.
Mr. Kearney was in the room, wasn't he?
In the courtroom?
In the courtroom.
Yes.
He got up as soon as he saw you and he left, didn't he?
I believe he was asked to leave by one of the court officers.
Mr. Kearney left and went out of the courtroom, right?
He did.
The hearing was quick and you were leaving with a big group of people, right?
Yes.
You left the courthouse There was a huge throng of people outside, and everyone was dispersing as they will from a court hearing, right?
Yes.
You were with a group of people. You exited the Dedham Superior Court, the Norfolk Superior Court. You made a right and you went behind the registry building to go to your car, correct?
I made a right.
Walked
crossed
across the street.
Yep, crossed over. And then, yes, went behind the registry.
And you were with a big group of people, weren't you?
Yes.
All right. And that's when you claim that you hear Mr. Kearney yelling, liar, liar, and you see him and perceive him and experience emotional distress from him, right?
Yes.
And he's violating the restraining order, right?
Yes.
Then you go to the back of the registry building with a group of people and you go to your car, right?
Yes.
And you think that somebody did something to your car, right?
Somebody did do something to my car.
And you call the police because someone did something to your car, right?
Yes.
And
Well, I did not call the police. I'm a member of the group I was with.
and Officer Kozak responded to a report about damage to a motor vehicle, right? From the Dedham Police.
I believe. I think that's what it was. Yeah.
And the time received was 14:32:06, so 2:32 p.m., right?
Sounds about right.
So he was there about 10 minutes after you got out of there, right?
If that's the time you have.
And you had just experienced a blatant violation of a restraining order from Mr. Kearney, calling you a liar, screaming at you, causing you upset, causing you to be in fear. That's your testimony, right?
Yes.
So you must have told Officer Kozak 10 minutes later that Mr. Kearney was in violation of your restraining order and that he should walk 5 minutes away and arrest him, right?
I told him about the violation. I didn't order him to do his job.
You told him about the violation.
Yes.
So Officer Kozak no doubt would have put that in his report, that you told him about a restraining order violation that just blatantly happened to you, not 5 minutes prior, 10 minutes prior to his response, right?
I would have thought so.
I'd offer this judge Officer Kozak's report. Speaks for itself. And sorry, Judge. Let me know when you're ready, Judge.
All right, any objection to this item?
No.
Okay, so this item will come in as exhibit number 3.
Yes, Your Honor. Enter exhibit 3.
You may proceed, Attorney.
Thank you. So you didn't report it to Mr. Officer Kozak? He didn't put it in his report because that never happened, isn't that right?
I did report it to Officer Kozak, and it did happen.
Officer Kozak came in to the hearing that you participated in based on your story here to try to revoke Mr. Kearney's bail and send him back to jail when this happened, isn't that right? He testified right in front of you, didn't he?
I don't remember him testifying.
Officer Kozak came to that bail hearing and he testified that you said nothing about any restraining order violation 5 minutes prior by Mr. Kearney, didn't he?
I don't remember.
Judge, I have Officer Kozak's testimony. I don't have a separate copy of it, but I can either, oh, I'm sorry, we actually have it on a flash drive. So I just would call your attention to that, invite your attention to that, if I may, as the fact finder, that you're going to have Officer Kozak's testimony from the prior hearing where Officer Kozak corroborates everything I just said about him and his own police report that Ms. Gaetani said nothing about any restraining order violation 5 minutes prior. So I offer that. Now,
That's not coming in, but I have the report and I have his narrative, which addresses that issue, and that has been entered as exhibit.
all right, thank you, Your Honor. I'll leave it at that. I can just have one moment, please, Your Honor. So, Ms. Gaetani, you know that Mr. Kearney's profession is as a journalist to cover the Karen Reed case, right?
I wouldn't say that's his profession.
Well, you know that Mr. Kearney is covering the Karen Reed case and reporting on it prolifically. Isn't that fair to say?
Yes.
And so if you're afraid of him, you could just not go to the Karen Reed case where he works. Isn't that right?
I could.
But you don't, correct?
I went to the Karen Reed hearing.
When Mr. Kearney announces that he's going to be at the Karen Reed hearing cases, sorry, strike that. When Mr. Kearney announces that he's going to be at the Karen Reed case hearings, you show up, when Mr. Kearney announces publicly on his Twitter feed or his Facebook that he's not going to go, you don't go. Isn't that right?
No,
And you only developed an interest in attending Karen Reed hearings after you got a restraining order on him. Isn't that right?
no, that's not right.
You're trying to use the restraining order as a sword rather than a shield to try to get him in trouble with it, rather than use it as protection. Isn't that right?
No, it's not right.
So you just have an abiding interest in the Karen Reed hearings and you want to go there all of your own accord?
I was interested in the case. That's how I met him.
You never went to a Karen Reed hearing until you got the restraining order. Isn't that right?
I didn't go inside the court, but I went to a protest outside.
Sorry, just if I could just have one moment, please.
You may.
Now, June 28th, you were at a Karen Reed hearing and you gave a media interview, correct?
I don't recall.
You walked right up to a camera right near where Mr. Kearney was and you started talking to the media, didn't you?
No,
It's fair to say that on many occasions, you seek out Mr. Kearney, you try to tweak him, you try to go to where he is and cause some trouble. Isn't that a fair statement?
absolutely not.
So you just have an abiding personal interest in the Karen Reed case that just coincidentally meshes with whenever Mr. Kearney is present covering the hearing?
No, I've only been to 2 Karen Reed hearings and I went to 2 protests and I never paid attention to if he was gone or what he was doing. And the 2 protests I went to were after that order was amended.
And you're also trying to keep the attention on you, keep the controversy going because you're trying to make money off it. Isn't that right?
No,
You have bragged about a big film deal that you're involved in where you're going to be played by someone and you're going to make money off of a film contract. Isn't that right?
that was a joke.
It was a joke.
Folks, quiet, please.
Now, in December of 23, it's fair to say that your relationship with Mr. Kearney had been winding down.
Yes, we broke up in early December.
And you called him in a fit of rage around December 9th, saying that you were going to be his worst nightmare and that he didn't know who he was fucking with and that you were basically going to get him. Isn't that right?
Just for the record, what year is that?
23, Your Honor.
I don't recall. I don't remember ever making those exact statements.
And you claim that you were pregnant with his child, right?
Yes,
And you showed him pictures of some sort of medical pictures that you claimed were linked to your pregnancy with Mr. Kearney, correct?
yes,
And in fact, those pictures, the metadata of those pictures showed that those pictures were a couple of years prior to any interaction with Mr. Kearney, weren't they?
that's what the metadata showed, yes.
And in December of 2023, you called Mr. Kearney on the phone using this pregnancy story, threatening to, quote, drop that fetal alcohol syndrome baby off at your house and party my fucking life away. You said that to him, didn't you?
When are you talking about?
On December 9th, 2023.
I don't recall the exact words I used.
You said that ending the relationship was going to be Mr. Kearney's, quote, biggest regret. You said it's going to be the biggest regret of your life to Mr. Kearney, right?
I don't remember. saying
And all of these machinations over the last year, reporting investigator 𝗄𝗏𝗃 to the police with nothing happening from it, reporting me to the Board of Bar Overseers with nothing happening from it, threatening to murder Mary Bagwell because of it. This is all part of your campaign to exact revenge on Mr. Kearney. Isn't that correct?
Don't answer that question. Again, that goes into the Fifth Amendment issue, Attorney Bradl, you know that.
I'm sorry, Judge. One moment, please. Now, you claim that you want to get away from Mr. Kearney, right? You don't want to interact with him. You're afraid of him. You want to just get him out of your life, right?
Yes.
So if one were to print out all of the texts, all of the tweets, all of the references to Mr. Kearney, they would probably be about 3 inches thick, wouldn't they?
I've never contacted him, and my tweets began 6 months after he had been harassing me, and I started to tweet the truth out there because he was defaming me all on the internet. So you probably find significant number of tweets from me, but I've never contacted him.
I'm just going to show you this pile. Take a look at that. Just leaf through that and tell me what.
Quiet, please.
Tell me when.
Folks, once again, quiet, please.
Tell me when you've done. And then I'm just going to ask you in general, what is that pile?
Most of these look like tweets from me responding to the lies that he's put out there about me.
All right, I'm just going to retrieve that back from you, please. Thank you. So it's fair to say that there's a 3-inch thick, and I'm going to spare the court the contents of this, Judge, and ask her to just describe that. It's a 3-inch thick pile of tweets criticizing him, needling him, provoking him, isn't it?
In response to probably a pile this high from him about me, yes.
And you gave that pile, as you call it, to the court here today, right?
No.
So you don't have it then?
If I were to print out everything that he has written and said about me, it would take me years. He does 3 shows a week that are 3+ hours long each. He has Facebook, Twitter, every social media platform post about me daily for the past year.
And every
Talks
time,
about me daily
sorry, go
for
ahead,
the past
finish.
year.
And every time he tries to defend himself, you accuse him of something else, don't you?
No, that's false.
Now, you also contacted him on February 22nd, 2024 at 1:57 a.m., didn't you?
That's the only contact I've ever had that I've already explained in court under oath. That was an accidental call when I was printing out evidence for my grand jury testimony the following morning. He was still in jail, and I accidentally hit the button because I fell asleep while I was printing, screenshotting and printing evidence from my phone.
So you have to go through 3 different efforts to unblock someone to then call them, right?
I didn't have him blocked. I had him unfriended. I never had him blocked.
Isn't it true that the printout of this call has an option to unblock him, which suggests that you had him blocked?
I
And I
took
can
the
show you that.
I already know. Yeah, I took the screenshot after because I blocked him immediately after I accidentally called him.
So this is a screenshot of your Facebook call to Mr. Kearney,
And that's
correct?
actually his screenshot. So that's his option to unblock me, which means he had me blocked.
As he should. I offer this judge as the next exhibit.
Folks, once again,
Then you
Objection,
also, oh, I'm sorry.
That's okay. Any objection?
I mean, I objected the testimony about it. It's not correct what he's saying, but
All right, thank you. This will be entered as exhibit number 4.
Exhibit 4, enter.
Attorney Bradl, you may proceed.
And ma'am, you also called Mr. Kearney Thursday, March 7th at 3:52 p.m.
no, I did not.
You texted him rather, I'm sorry.
No, I did not.
You did not. Let me show you this document. Have you ever seen that before?
Yes, I saw it in court at one of the hearings.
And that's a text that you wrote to Mr. Kearney on that date, even though you had the restraining order, right?
Absolutely not. A text is not from me.
Well, it talks about things that only you would know, right? Like the fact that Mr. Kearney was arrested.
I don't know how that's something that only I would know. Everybody knew it was on the news.
Well, the message talks about his girlfriend Meredith. It talks about that he's going to jail, or he can live stream right now, apologize, and call yourself a little bitch, and you have 15 minutes to do so. Didn't you send that to Mr.
No,
Kearney?
I absolutely did not.
Because the text message also indicates that the police came and looked at your cell phone that day, and only you knew that. Isn't that right?
The police didn't come to look at my cell phone that day.
Hey, cops came up and asked to look at my phone and said you filed a complaint. So the text is in first person as if it's from you, right?
Wasn't me.
So you're saying that someone else just took it upon themselves to pretend to be you and address Mr. Kearney demanding an apology?
There's nowhere stating on that message that they're pretending to be me. You're alleging that it's me based on your own made up story. It's not. It wasn't from me. I didn't text him. I have not contacted him. I want nothing to do with him. I don't text him ever, and I never have.
Well, the 3 inches of needling that we just went through show that you do want to mess with him. You do want to engage with him. Isn't that right?
No, I want to defend myself against the disgusting lies that he keeps spreading about me on his platform that has hundreds of thousands of viewers. I don't have an outreach like that. So he has destroyed my life with his lies.
Now, back to Ms. Bagwell for a moment. She went to the Attleboro Court and got an order on you, correct?
Correct.
She also is the complainant in a pending criminal complaint matter as well. Isn't that correct?
I don't know.
How long is the harassment prevention order against you in effect for?
1 year.
Do you have a date yet for the clerk's hearing as to the criminal complaint?
No.
That's all I have, Your Honor. Thank you very much.
All right. Do you have any other evidence you want the court to consider?
No, Your Honor.
Because you rest at this time.
Yes, I do.
Attorney Bradl, do you have any evidence you want the court to consider?
Judge, I'd ask that the court enter a required finding relative to the lack of reasonable fear of imminent bodily harm. As the court's aware, the plaintiff needs to establish anew that they have a pending current reasonable fear of imminent serious bodily harm. There's been nothing in the record other than a generalized fear of disparagement. And on the face of the record, as it stands, getting pushed to the couch over a year ago, wouldn't satisfy as a matter of law any sort of incident that would validate a fear of imminent serious bodily harm. One thing about the legal profession, Judge, is that words have to have meaning. We all have to agree on the meaning of words. And imminent means something. Imminent is an element of that charge. And there's no imminency here. And there never was any imminency. And if the court wishes to hear more, we would put on Ms. Bagwell and Mr. Kearney relative to this one precipitating incident over a year ago never happening. And so that's a factual issue. But in terms of we'll do it if the court doesn't rule in our favor on this. But the state of the plaintiff's evidence, before we go any further, is that she has a fear of disparagement. And, it sort of reminds me of O'Brien v. Borowski, Your Honor. Fear of being sued or fear of being disparaged is not a fear that can overcome the Constitution. It's not a fear that is lawfully recognized, especially in the 209A context, where the standard is reasonable fear of imminent serious bodily harm. So I would ask the court to enter a required finding against the plaintiff.
Which is not a typical motion in a restraining order. I'm going to make my conclusions after I've heard all the evidence. The motion for required finding is denied.
I appreciate it, Your Honor. I'd call Mary Bagwell, please.
Step forward.
And I think she's just right outside the door.
Sure.
Mary Bagwell? Stand on the chair, please.
Would you raise your right hand? Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
You may sit or stand, whichever is more comfortable for you. Please keep your voice raised for the record.
May I inquire? Thank you. Hi, Ms. Bagwell.
Hi,
Please state your name and spell your last name.
Mary Bagwell, BAGWELL.
And do you live in the town of Mansfield?
Yes, I do.
Are you pretty much a lifelong resident of Mansfield?
Yes,
Do you have a family?
yes.
And who are they?
I have two sons, Jacob, he's 17, and Aaron, he's 29.
All right. And you're in the finance and accounting industry,
Yes, I am.
and you work for a government contractor here in Massachusetts?
Yes, I've been there for 24 years.
All right. And you're a single mother of the boys?
Yes, I am.
Do you know the person sitting at the desk right in front of you here?
Yes, I do.
And who is that?
Lindsey Gaetani.
How do you know her?
We,
Just in general.
we used to be friends.
And when did you first meet her, just in general?
April of around the springtime of 2024.
And what was the context of meeting the plaintiff?
We did protests together.
And that was just to kind of move it along. It was the Karen Reed murder case, and you would protest in favor of kind of the prosecution position. Is that
Yes,
right?
Yes.
Okay. And so just so we're fair, it's not a position that was shared by Mr. Kearney, to your knowledge, right?
No, it was not.
Okay. And what were the kind of what was the nature of your relationship with Ms. Gaetani, and how did it develop in a nutshell?
We started talking on the phone through a mutual friend. She would call us on a three-way call. After a couple of calls, then we all created they created a group chat in the Messenger app, and from there we would frequently, almost every day, we would all be either audio calling or video calling each other. So we regularly stayed in contact.
Okay. And with respect to, strike that, you're aware of the criminal case that Ms. Gaetani is involved in, where Mr. Kearney is charged with violating a restraining order, right?
Yes, I am.
And you're familiar with the case where Mr. Kearney is accused of being at her house on the 23rd of December of 23, and some sort of altercation happened. Is that right?
Yes.
And so you were aware of these things when you were friends with Ms. Gaetani?
Yes.
Did Ms. Gaetani have a conversation with you in the summer of 2024 about the true events that happened at her house on December 23rd
Yes.
of 23? What was the conversation?
She had told me that Aidan had taken notes from her phone, and he wrote them down in a notebook. When Aidan wasn't looking, she said that she ripped the pages out of the notebook and shoved them down her shirt. Aidan went to get his notes and noticed they were gone. He asked Ms. Gaetani where the notes were, and can you give them back to me, please? And from there, she ran into the bathroom, locked the door, and called Ken Mello. And she said that Ken, he didn't answer. And that she had also stated that he didn't push her on the couch or assault her. He was just grabbing at the papers. He was trying to get his papers back.
Did she, strike that, did you say anything to her about what you thought she should do in light of what she had told you?
I said, you need to tell the truth. And she said, I can't, because I have to stick with what I've already said.
Was there anything else, if you can recall, about that particular conversation about the incident involving Mr. Kearney?
She just felt very bad of what she did. She seemed to be struggling.
Did she ever, to your knowledge, act on feeling bad about it, or did she return to pressing that position?
Did she what? I'm sorry.
Did she act on that? Did she, to your knowledge, did she go to the police and explain it? Did she put out a tweet recanting it?
No.
To your knowledge?
No.
Did she return to the prior position that's what happened?
Yes.
Now, as your relationship with Ms. Gaetani evolved, is it fair to say that the relationship got somewhat antagonistic?
Yes.
And tell us about that. What happened with respect to Ms. Gaetani and the way that she treated you, just in a nutshell?
I was just trying to help her get help with her drinking. There was an incident on June 18th, 2024.
Well, let me just stop you there. I don't want to go through a whole litany of things.
Okay.
But is it fair to say that you wrote an affidavit and signed it and provided it to the defense today?
Yes.
All right. And Judge, I'd offer that affidavit as the next exhibit.
Yeah, I mean, I'm not gonna take the affidavit as an exhibit. I'll certainly hear her testimony, so you
Sure.
can elicit whatever you wish.
Very good, thank you, Your Honor. That's fine, thank you. Now, as the relationship kind of winded down between yourself and Ms. Gaetani, how did she treat you?
She made threats to me. She called me and she threatened me, and she told me that I needed to shut my mouth and be quiet.
Did she threaten to murder you?
Yes, she did.
Did she threaten to murder your kids?
Yes, she did.
Were there more than 3 incidences of this type of behavior from Ms. Gaetani?
Yes.
And did that prompt you to take some advice and go to the Attleboro court for an order?
Yes, it did.
And you got a criminal harassment order on her?
Yes, I
And
did.
that was fairly recently?
Yes,
When was it?
December 10th, my birthday.
And Ms. Gaetani went there and she testified, right?
Yes, on December 24th.
24th
For the two-party
two-party hearing. Got it.
Yes.
Thank you. And you witnessed her admit some things about your relationship and what happened, right?
Yes.
Did she admit threatening to murder you and your children?
Yes, she did.
What'd she say?
She admitted into the, well, first when my lawyer asked me if there was any criminal charges pending, I said yes. And then the judge stopped and advised Ms. Gaetani of her rights. And she went into great detail and explained it. And then when she got to the December 10th date, she said, I highly recommend and urge you to stay quiet. And she did not listen to the judge. She admitted to everything. She admitted that she felt remorse. She felt ashamed of her actions of like threatening to come to my house. She threatened to kill me. She threatened to rip my fucking head off and to come to my house and murder me and my children.
How many separate incidences were there of that kind of behavior from Ms. Gaetani towards you?
There were several.
Can you just put in a little more than several on it? What are we talking? A dozen, 8, 10, 6?
3.
3? Okay. What about calls from a block number?
Yes, yes. She admitted to Officer Kelly from the Mansfield Police Department. I did receive a phone call from Officer Kelly, and he stated to me that Ms. Gaetani went down to the Mansfield Police Station and that she admitted.
I'm not gonna accept this testimony.
Hold on there, I'll ask you another question.
Okay.
Next question.
So just what you saw her say, tell the court just in general, the important things that you saw Ms. Gaetani say right out of her own mouth.
She admitted that that was her on the recording and that she threatened to murder me and my children.
Nothing further. Okay. Thank you.
I mean, this is your opportunity. If you have any questions for this witness, you may inquire.
Stand up, please.
Isn't it true that you went on a talk show the night that you claimed that I called you and made threats to you?
Not that night, I did not. It was the day before.
It wasn't that night?
It wasn't that night. That was December 9th. When you threatened to murder me and my kids, it was December 10th.
December 9th was the talk show, and you went on a talk show,
Yes,
and you called in.
I was asked to call in, yes.
You were asked to call in. By whom?
By the moderator and the hosts of the shows. They asked me to call in because you and your friends have been attacking me on Twitter for over 2 months. And I don't have a Twitter, and you knew that, and
Wait
everyone
for the
knew
next
that.
question.
Do you realize that there is a recording of this entire show on YouTube?
Yes,
So you're stating under oath
there's a recording of what?
the show that you called into,
I mean, I haven't seen it. I just called into
but
it.
you're aware that it was recorded. and
There
it's
was,
published.
all I talked about was how my son saved your children 3 times from drowning because you were too drunk and too
I'm asking you if you're aware
intoxicated.
that it's published online.
I don't
Because
know
you're
if it's
claiming that
published
somebody asked you to
online.
call in.
I don't know if it's published online or
So
not.
you called into the show, and one of the first things you said was that you have been involved with the Karen Reed case, that you initially believed that she was guilty, that you no longer believe that, and that Turtleboy loves you. Did you not say
I
that?
did not say that.
So if we were to pull up the show
I
and
would,
play it today, we would not hear you say that Turtleboy loves me.
Turtleboy loves me. I didn't know.
So it's not true that you flipped sides, so to speak, for lack of a better word, went from being an anti-Karen Reed person or anti-Turtleboy person to a pro-Turtleboy person before you called into that show and made several statements trying to help his case against me publicly on chats on YouTube, various YouTube shows.
I wasn't trying to help him. I have my own freedom of speech. I was lied to by you and Kate. So yeah, I stopped listening to you guys. That made you guys upset. I didn't follow suit. I had my own opinion. I started looking at the other
Answer the
news
question.
channels.
Do you have any proof of anything other than cordial interactions between you and I before the night that you called into that show, talking about my children and making up lies about my children?
I didn't make up any
Do you have any
lies.
proof of anything other than cordial interactions between you and I before that night?
I have a recording. Yes, I do.
Other than that night, do you have any proof of anything other than cordial interactions between you and I?
No.
So there's nothing except cordial interactions in text messages, on Messenger.
When people talk on the phone, you don't record them. When you talk, you're a very smart person. So when you don't make your threats in writing, you say it in person to that
Isn't
person.
it true that you testified under oath at the restraining order hearing that I made a threat to you on a specific day, and later that day I provided evidence where you texted me telling with heart emojis and asking how I was and were being friendly with me this very same day that you claimed that I threatened you?
We were talking on the phone. That was prior to the end of the phone call is when you made the threat. So when I sent the text messages didn't go through until we hung up.
Isn't it true that you called into the show that night making up lies about my children because your friend had
That's not
private
true.
probate documents released and believed that it was me that posted them, and that you
No.
conspired to call into the show and make up lies about my children
No,
and try to support the defendant here?
no, that's not true.
Isn't it true that this is retaliatory and you're making this entire story up in your affidavit about this conversation where I allegedly told you that this assault never happened?
That's not true.
I have no further questions, Your Honor.
Okay, thank you. Any redirect?
No questions, Your Honor.
Okay, thank you, ma'am. You may step down.
Okay.
Defense calls Aidan Kearney, Your Honor.
All right, so just remind you, you're still under oath. Please be seated.
May I inquire?
May I inquire?
Thank you. Good afternoon, sir. Please state your name, spell your last name for the record.
My name's Aidan Kearney, Kearney.
And what do you do for a living?
I'm a journalist.
And what are you currently working on?
The Karen Reed case has been my passion for the last year and a half.
How many articles have you written and published approximately on the Karen Reed case?
463.
How long have you been covering it?
20 months now, 20 months.
How do you know the plaintiff?
We had a brief sexual relationship,
And when was that, just in general?
September of 2023 to December of 2023.
Now, in that relationship, would you characterize it as carefree or difficult?
Difficult.
And why?
She would hurl abusive language at me a lot, especially when she was drinking, demean me, make me feel like I was not a good person in order to just beat me down.
Now, at the time, you were still married, correct?
I was.
And what was the status of your marriage?
Sleeping on a couch, and as far as that went, I guess I was living with my wife, still legally married. She's my ex-wife now, but it was not good.
Were you, is it fair to say that at that point when you took up with Ms. Gaetani that you were mutually going to end your marriage?
I'd say so, yes.
Now, Ms. Gaetani, at the winding down of your relationship, told you that she was pregnant, correct?
That's correct.
And tell us about what happened with respect to the circumstances of that in a nutshell.
She told me that when things started getting bad in the relationship and it seemed like it was going to end, she told me that she was pregnant, and I couldn't. Obviously, that made it a lot more difficult to end at that moment. And it caused a lot of anxiety and issues with me, obviously, because I have 2 children, and this would obviously cause a lot of issues. The entire time, as it turned out, the whole thing was a lie. and it was causing a lot of mental anguish in my life to the point where one night I had a really bad panic attack, and I started I just wanted to disappear. It's hard to explain. And I started walking down the road, and in the dark, and I sent her a video of myself walking down the road in an extreme emotional distress state.
Let me stop you right there. I want to ask you about that. You heard the plaintiff say to the court that you have mental health issues. Where would you say any mental health distress that you have came from?
From her lie about being pregnant. And
Now, at some point, you started to stand up to her and break it off. Isn't that right?
yeah, once I figured out later on in the relationship where I began to have serious doubts about the pregnancy and she couldn't answer questions for me, I attempted to end the relationship on December 9th.
And you received a call on the phone from her that day, correct?
I did.
What was the tenor of that conversation from her end?
Very threatening. She said that she wanted, I told her that if she was pregnant, I was worried that the baby would have fetal alcohol syndrome because she drank so much. And she told me that she was going to drop that fetal alcohol baby off of my house and party the effing night away. And then she said that she's going to be my biggest regret, that she will fucking destroy me. And she just basically said, like, if you leave me and don't talk to me, I'm going to ruin you.
That was on a December 9th phone call. Is that right?
That's correct.
Now, sounds like that probably ought to have terminated any contact with this woman.
Yes, we didn't speak for about 10 more days around there.
So what happened with respect to kind of reapproaching each other? How did that happen?
Well, first she attempted to coerce me to come over to her house with the promise of a threesome. That was on December 21st, and I didn't go. And then on December—
Was that through text messages?
That was through text messages, correct.
Yeah, go ahead.
And then on December 22nd, that was the day I was arraigned. And
Is that a Friday?
I don't remember the day of the week.
So it was an arraignment in the Superior Court, is that right?
That's correct.
So it's a case where you would have been indicted, is that right?
That's correct.
All right. And did that indictment have anything to do with Ms. Gaetani?
No, it's completely independent of her.
All right, go on.
And as soon as I got home, I got a message from her alerting me that she had just been visited by State Police Detective Brian Tully, who is kind of spearheading my case. And he had given her a summons to testify in what appeared to be a grand jury in my case on December 27th.
Were there a couple of things that Ms. Gaetani referred to in an effort to have you come to the house?
What do you mean?
So you had this information about a pregnancy at the time. You weren't sure what
Correct.
the status
Yes.
was, is that right?
Yeah, she was insisting that she was pregnant, and
were you asking her for some sort of corroboration or something?
I was.
Did you ever receive anything?
I received some photographs, including a pregnancy test that had metadata on it showing that the image was taken in May of 2023. I also received a picture that she sent me in late November of what she claimed was her at an abortion clinic in Brookline, she said. I later found out through metadata that picture was taken on December 4th, 2021. So the pictures she was sending me of evidence of this alleged pregnancy were all old photographs that she had taken from prior pregnancies.
So you have the pregnancy issue, and then you have a subpoena, is that right?
Correct.
What happened with respect to a subpoena? How did that figure into this?
Well, like I said, the attempts to get me over her apartment with sex wasn't working. And so she sent me this picture of a grand jury summons on December 22nd and said, I want you come over tonight and talk about it. And I said, no. I actually called you and alerted you to it, and you advised me not to go. And so I informed her that I would not be going, at which point she, threatened me and said that, well, if you don't come over, then I'm going to do what I have to do, and I'm going to tell the grand jury about the baby.
So you went over there, and did you try to limit your private encounter with her?
So the next day, so I initially told her I wasn't going to come. And then early on the 23rd, she then continued to tell me that she was pregnant and that she wanted to discuss that. And so she'd also told me that she had been speaking with a woman by the name of 𝗵𝗵𝗄𝗏, who was antagonistic towards me, and that she wanted to come clean, and she said, and show me all the messages in her phone. And so I agreed to do so. I told her I want to meet in the conference room because I don't really trust you right now. And the police have been in your apartment. I don't trust them. So I'd like to meet you in a common area. And so we sat in the common area for 2 hours in her Medfield apartment. And
What were you doing during that 2 hours?
well, we began to look through her phone in the common area, but she started receiving phone calls from her son, it was a lot of phone calls, and this had never happened before. And he called like 7 or 8 times, insisting that she come back into the apartment.
So the kids were up in her apartment?
That's correct.
How old are the kids?
2, 3, 5, and 11, or 12 at the time, I think.
So what happened with respect to you trying to stay in the common area or go into her apartment?
So she said, that I have to go in there now. Just come in here. Everything's going to be fine. And so I said, okay. And we went into her apartment. We continued to look at her phone. I never once touched the phone. She held it the entire time. And I took notes about what was in her phone. I was shocked and horrified about some of the things that I was seeing. And then at about 2:30 or 3 o'clock, we were done, and we were intimate. And shortly after that, it was Christmas Eve morning at this point, and I had to go home.
So it's like December 24th, like 3, 4 in the morning?
That's correct, about 3 in the morning. And I wanted to go home. And the best way I can describe it is she lost her mind. She snapped, and she said, "You can't leave me." And she then took what she claimed was an abortion pill, even though she wasn't pregnant, and said, "Now you can't leave me here. You can't make me do this abortion by myself." And I said, "I have to go home. It's Christmas Eve and you're not pregnant." And she then told me, she then woke up all 4 of her kids, started screaming at them manically, and said, taking their coats out and saying, "We're going to drive to Aidan's house so I can have an abortion in the driveway. And if I bleed out and crash my car along the way, then it's going to be his fault." She frequently had done this before, threatening to kill herself and leave notes blaming me.
In response to hearing that display, what did you do?
I agreed reluctantly once the 5-year-old came out, and he just had a look of horror on his face. It's something I'll never forget. And for the sake of the children who I thought were in danger if she actually followed me to my house, I agreed to sit. She wanted me to stay for 3 hours. And so I sat on her couch until around 5 a.m. When she finally fell asleep. And then I walked out of the apartment and I drove home.
Did you assault her?
Absolutely not.
Did you throw her on the couch?
Absolutely not.
Did you grab her wrist?
Absolutely not.
Did you get in a struggle over pieces of paper?
Absolutely not.
Did she lock herself in the bathroom at some point in the evening?
Yeah, she did at one point go into the bathroom.
The next day, you later learned that she went to the police actually came to her, right?
Yeah, according to the police report, she called State Police Detective Brian Tully at around 11 o'clock.
She didn't call her town police?
No, she actually called 𝗵𝗵𝗄 for several hours. And we don't know what they discussed, but they spoke on the phone for a couple hours.
And you know this from discovery in your case, correct?
That's correct.
And the call to Detective Tully is the detective or the lead detective on the case that you were just indicted for, right?
Yes, he's the lead
Arraigned
detective.
the
That's
day
correct.
before.
And the Kearney case.
Nothing to do with Medfield police, nothing to do with domestic violence, correct?
Nothing.
To your knowledge, and you're having all the discovery in the case, to your knowledge, did Ms. Gaetani ever call 911 or call her local police department or anything to that effect?
No, Brian Tully did.
And what happened with respect to Mr. Detective Tully calling the local police? Again, based on the discovery, what did you learn happened?
That Detective Tully called the police, and he's the one that told them that an allegation of assault, that she's claiming that she was assaulted. She never told them that initially. And so the Medfield police came to her apartment on Christmas Eve and spoke to her. And then she then told this story about me stealing paper her stealing paper from me, and then me assaulting her because of that.
And that resulted, just to put a quick point on it, that results in charges against you. You come to this court, you get your bail revoked for 90 days. You end up being in jail starting on Christmas, the day before Christmas.
Day after.
Day after Christmas, sorry. You're in court on your birthday and you get your bail revoked and you're in jail for, the order was 90 days, but we got it back to 60 days, correct?
Yeah, I was incarcerated for 60 days.
And with respect to the incarceration, your mom was ill at the time, was she not?
She had pancreatic cancer.
And that was two months out of her life that you were deprived of, and she's since passed away. Isn't that right?
She died in June.
So with respect to engaging in any conduct whatsoever that may have ever created a reasonable fear of imminent serious bodily harm, is there anything you can think of that you may have ever done to her that could ever satisfy that standard?
Nothing.
Did you ever create any revenge porn accounts against Mr. Gaetani?
Absolutely not.
Did you record Ms. Gaetani in this alarming evening that you described for the court? Did you resort to recording Ms. Gaetani's outbursts, shall we say?
I did,
Why'd you do that?
because I was scared for the children and I wanted to do it for my own protection.
Did you tell her?
Yes, I told her. I alerted her. That's correct.
And you have those tapes, correct?
I do.
Then fast forwarding, Ms. Gaetani brings this February 26th, 2024 restraining order violation case, correct?
That's right.
Or she's involved in it, I should say, Judge. She's involved in that case, right?
That's correct.
So that case, taking the allegation there as it is, doesn't allege any violence or anything whatsoever relative to creating bodily harm. Isn't that right?
Yeah, that's right.
The allegation there is that you were in a certain proximity, correct?
Yeah, and then I yelled, liar, liar.
Judge, that's all I have. Thank you very much.
All right, so we still have cross-examination and closings. It's 1 o'clock right now, so we're going to take the luncheon recess. We will resume promptly at 2 p.m. At 2 p.m., ma'am, you may inquire of this witness. Thank you.
Thank
Thank
you,
you,
Your Honor.
Judge.
2 o'clock.
Court, all rise. Who's going to stand to the recess?
Should be open.
Clerk.
The judge. Wait, remain quiet in the courtroom. Thank you.
Good afternoon, Your Honor. We are back on the record.
Good afternoon.
Your Honor, would you like Mr. Kearney to resume the stand?
Please, sir, if you could please resume the witness chair. And as I said before, I remind you, you are still under oath.
Your Honor, if I may, I did speak with him. He just has a couple of things he wants to get out to the court. If I could have the indulgence of asking a couple of additional questions before invest.
We have not turned to cross just yet. We're about to begin that, but yes, I'll give you a couple.
Thank you. I appreciate it, Your Honor. May I inquire?
You may.
Mr. Kearney, you have been under this order for how long now, sir?
It's been 1 year.
Under the year of the order, how has that affected your actions, your behavior, your mental state?
I live in constant fear of going back to jail due to the existence of this order and her history of attempting to weaponize the order to trigger a violation. I'm constantly in fear that she's going to show up at my kids' basketball games and my kids' soccer games because she's shown up at so many places before. On June 28th, she showed up at I was outside the courthouse supporting Karen Reed, and she barged through, the group that I was with. And I literally had to run for safety and find a police officer and say, there's a person here who has an order against me, and I want to document this and film this and let you know I am walking away. I'm trying to stay away from her. I'm just constantly in fear because of the existence of this order. And I have to see a therapist. The 60 days away was extremely traumatizing. I have 2 young children who didn't know where I was for 60 days. And on March 14th, we had another bail revocation hearing 20 days after I got out of jail. And I found out that they wanted to send me back for 120 days because she showed up to where I was at the courthouse on February 26th.
That was the incident we discussed here about you having to leave court.
That's right. And I left and I went to where a police officer told me. And I just remember thinking, like, where can I go that's safe? I just signed up to be my kid's basketball coach. And I had to actually think, like, well, what if I go to jail? Who's going to coach the team? Like, should I even do this? Because I'm constantly living in fear because of the existence of this order.
Do you have any interest at all in engaging her, provoking her, being anywhere near her, assaulting her, harming her, talking to her?
No, I want to be as far away from her as possible.
Thank you.
All right, thank you, counsel. So, ma'am, this is your opportunity to inquire whenever you're ready.
Mr. Kearney, you're charged with violating this order, and there's a pending criminal case in this very court for that, correct?
That's correct.
And I am the named victim in that pending criminal case. Isn't that correct?
That's correct.
And separate to that, you also have an open felony case in the Norfolk Superior Court related to the charges of wiretapping and witness intimidation against me, correct?
That's correct.
I'm also the named victim in those pending felony matters as well, correct?
That's correct.
You're also facing numerous other felonies in regards to witness intimidation and other charges, correct?
That's correct.
With other separate witnesses, correct?
That's correct.
Mr. Kearney, do you remember? Or let's see, straight that. Episode 645 of your YouTube show on March 12th. You said the following, didn't you? And I'm quoting you. And hopefully that continues on Thursday because I don't want to go back to jail. That would suck, especially over some bullshit lies. This shit needs to end, man. This shit needs to end. But I got a great attorney and a great defense team, and we're gonna fight hard and we're gonna win. We're gonna take them down, man. I'm not going to jail. Fuck that. I already did my time. If they send me back to jail, I know it would be somebody's like, yeah, people would riot. People would be fucking outraged because everybody, when I was sent to jail for the first time, you guys didn't know about Lindsey Gaetani. You didn't know her. Now you know. You said that, didn't you?
I'd have to hear it.
Another episode, didn't you also say, who's the scary one, me or them? Me? I'm the one that knocks, motherfucker. They should be a million times more scared of me than I will ever be of them because I'm a relentless, vengeful cunt, hell-bent on putting them all in prison. If that doesn't scare the shit out of you, what does? And I got a large platform to do it. And I'm fucking smart and savvy and I know what the fuck I'm doing. You said that too, didn't you?
I don't recall saying that.
Mr. Kearney, you mentioned that you sent me a video, which you described as showing you having a panic attack. Is that correct?
That's correct.
And in that video, isn't it true that you were walking down a dark highway, threatening to walk into oncoming traffic because I tried to break up with you? Isn't that correct?
That's incorrect.
Isn't it true that you hung up
Hold on a
after?
minute. Stop. Take that computer and leave the courtroom. This is the second time I've warned you. I'm going to make this as clear as I can possibly make this. Okay? Don't shake your head. Be quiet and listen. Okay? What's your name?
Grande Smith-Ellis, Your Honor.
All right. Sir, you did not ask permission to record this. You did not ask permission to videotape these proceedings. You have a laptop open. I can see the light illuminating throughout this proceeding. Don't shake your head. Keep listening. Okay? I'm warning you now. Okay? If I see you recording, if I see you videotaping in defiance of my previous notification to you not to do so, you'll be fined up to $2,000 and sentenced to up to 90 days in the House of Correction for each contemptuous act that follows. Do you understand that?
Yes, Your Honor.
Okay, take the computer and remove it from the courtroom. You are welcome back in, but the computer is not.
Thank you, Your Honor.
Thank you.
I just want to tell you that gentleman has nothing to do with the defendant or the defense.
Okay, I don't consider him having anything to do with either party.
Thank you.
I just know he was an individual in the gallery that was recording or attempting to record in an unauthorized fashion, and he's been warned. Ma'am, you may proceed.
Thank you. Isn't it true that you, after you threatened to walk into oncoming traffic, that you shut your phone off, you hung up and shut your phone off, and called me back an hour later, acting like nothing had ever happened?
That's incorrect.
Isn't it true that this wasn't the first time that you threatened to kill yourself when I tried to break up with you or wouldn't answer your calls?
You've never tried to break up with me.
Didn't you also do this before knowing about my pregnancy? Because you would use that as your excuse for your alleged panic attack.
You were never pregnant.
Isn't it true that you used similar threats with another ex-girlfriend and threatened to kill yourself with an extension cord when she tried to break up with you?
That's incorrect.
Didn't you admit on your YouTube shows about needing to take a break in the past because of your suicidal ideations when you were caught cheating on your wife?
I've had to take a break for mental health issues before.
You claim that I lured you to my house on December 21st for a threesome. Isn't it true that you willingly came to my house on December 20th and had sex with me?
I did.
And if I wanted to set you up, I could have done so then, couldn't I?
You could have.
I didn't need to lure you to my house because you came over my house willingly to have sex, correct?
Not on the 22nd.
Mr. Kearney, you took me to a bar in Norwood in October 2023, isn't that correct?
Yes.
Were you aware that night that I only had 2 drinks?
No, you had more than 2 drinks.
After the trip to the bar, you drove me home, isn't that correct?
I did.
During that drive home, I refused to engage in sexual activity with you, isn't that correct?
That's incorrect. It's not, I didn't ask for it.
Did you not claim on many of your YouTube shows that I, quote, refused to give you roadhead?
On which night are you talking about?
The night in question October of 2023,
Which,
when we went to the bar in Norwood.
which day? We went a few times.
The night in question, when we were driving home, you just answered that you drove me home after the bar. Isn't it true that you stated to your audience that I pretended I had to throw up to get you to pull over to the side of the road?
You were berating me and telling me that.
Isn't it true that you stated that I pretended I had to throw up?
Your objection is sustained. You may finish your answer.
You were berating me, dehumanizing me, telling me I was worthless and what a horrible person I was. And then you said that you had to throw up. And I pulled over, and that is the reason that there was no sexual relations in the car on the ride home.
Isn't it true that after you pulled over and I got out of the car to pretend to throw up, that you stated that I ran down the middle of the street in the dark to try to escape from you?
You were not, you began walking down Route 109 in Westwood in the dark.
Isn't it true that you also stated that a couple in a car pulled over to try to offer me assistance?
That did not happen. I do not recall that happening.
Isn't it also true that you stated that you then persuaded me to get back into your vehicle?
I did not want you to get hit by a car. I was worried about you, so I asked you to get back into the car.
Isn't it true that we then went back to my apartment?
That's correct.
Isn't it true that at that point I was blackout drunk and you raped me?
No, that's incorrect.
Isn't it true that you recorded the rape?
It's incorrect. I did not
Isn't it
rape
true
you.
that you showed the recording of the rape to multiple people?
You showed it to the police and they said it wasn't rape.
That is not what the police stated in the report.
It
Isn't
is.
it true?
Objection to counsel testifying to the plaintiff testifying your own motion straight.
Isn't it true that you got a copy of the rape?
Hold on. As to that last objection, sustained, motion to strike allowed. Next question.
Isn't it true that you got a copy of the police report regarding the rape during the discovery process for your current criminal trial, and you gave it to another person on an anonymous Twitter account to post publicly, completely unredacted, with all of the sexually explicit information and details about the rape and my identifying information?
Objection. Sustained.
Mr. Kearney, on February 23rd, you were indicted on the wiretapping and witness intimidation charges. Isn't that correct?
That's correct.
On February 28th, are you aware that I was called to the Medfield Police to answer to false claims of you reporting me for wiretapping?
They were not false claims. You did wiretap me by putting a Ring camera video in your bedroom and filming us having sex without my consent.
Isn't it true that I was not charged with wiretapping?
Not yet.
Isn't it true that on February 26th, you violated the restraining order, and a mere week later, on March 6th, you then went to the Dedham Police to file another retaliatory claim against me for filing a false police report?
I never violated the order, and I did go to the Dedham Police to file a factual false police report against you because you lied in the report by saying that I yelled "liar, liar" at you when video evidence shows that no such incident occurred.
Mr. Kearney, on March 14th, 2024, you had an arraignment for an RO violation and hearing for dangerousness, bail revocation, Aidan District Court in front of Judge Pomeroy. On several weeks later, April 11th, you posted and announced on Twitter that you were filing a motion to try to have my restraining order vacated. Isn't that true?
I did file a motion to have the restraining order vacated.
Based on these instances, wouldn't you say it's fair that this tit for tat retaliation has been on your behalf, not mine?
I don't understand the question.
You stated that the Dedham Police informed you while you were recording that you could stand, this is on February 26th, that you could stand on the steps of the Registry of Deeds and that would be fine. Isn't that correct?
He said, "Go over there." And he
But Mr.
pointed.
Kearney, when Officer Crump testified on March 14, 2024 at the Dedham District Court, he told the court that at no time that at the time he did not know who you were talking about and where you were talking, where the person was at the time. Isn't that correct?
He told me to go stand over there, so I went to where he told me to stand.
Isn't it correct that he said you should go stand over there for now and then we would figure it out?
He said something to that
Mr.
nature.
Kearney, you
Correct.
never followed up with that officer again at any point after that, did you?
Within 5 minutes, the hearing was over.
Mr. Kearney, isn't it true that after you followed me to my car, the following day you wrote a blog about me, a very lengthy blog in which you posted numerous pictures of me, videos of me, slandered my name, and made light of the situation?
I never followed you to your car. And I don't make light of any of this.
I have nothing else, Your Honor.
Maybe Director Attorney Gray.
Yes, Judge. You ever been charged with rape as a result of any allegation from this plaintiff?
I've never even been questioned by police about it.
And you received a police report and discovery about it, correct?
I did.
And the police report goes through all of the texting and the police review of the videotape from the sexual encounter that you had that night with Ms. Gaetani, does it not?
The consensual sexual encounter, correct?
And the police reviewed it, wrote a report on it, talked all about the text exchanges between the two of you, correct?
Correct.
And the police report recreates all of them, doesn't it?
Yes.
And in those texting, she indicates in a nutshell that she doesn't remember the night before, correct?
I believe something of that nature,
As
yes.
opposed to that she didn't consent to the night before. Her statements to the police are that she didn't remember the night before, right?
Yeah, she specifically said, you know, I don't care.
She said, I mean, I don't care. I just wish I could remember it because it takes away all the fun not being able to remember a single thing we did. And I only remember getting out of the car. So she was not upset in any respect about the sexual encounter the night before, was she?
No, she was very excited about it and very happy about the video when I sent it to her.
Judge, I'd offer the police report on that in 2 evidence.
Yes. Any objection? Madam Plaintiff?
No, Your Honor.
This item will come in as exhibit number 5.
Yes, sir.
Any further redirect?
Just one moment, please, Your Honor.
Sure.
Now, in the district court, Mr. Kearney, you were charged with assault and battery on a family or household or dating relationship person, correct?
I was.
And that case was taken to Superior Court, was it not, through indictment?
It was taken to a grand jury.
And after that, it went to Superior Court, correct?
I don't think it never made it that far
Well, not
because,
the charge, the case in general, I'm sorry, I'll ask you a better question. The case in general was taken out of here to the Superior Court, correct?
yeah, 2 of the 3 charges ended up making it to Superior Court.
And with respect to the assault and battery charge, was there, again, from your knowledge of the discovery in the case, was there a request from the prosecutor, Mr. Novak, to obtain an indictment from the grand jury on the same charge from here, the assault and battery charge?
Yes, Mr. Novak asked the grand jury to indict me on assault and battery.
And in terms of the charges that emanated and were brought in Superior Court, did that assault and battery charge get out of the grand jury?
No, it did not.
All right, and you've seen the judge, just a little guidance from the court, if I may, Your Honor. I have 1 page from the grand jury, which ought to be impounded, I suppose, that corroborates my client's testimony that Mr. Novak asked for A and B indictment, and it was not granted by the grand jury. And I also have the docket from that case in Superior Court, which lists the charges with there's no assault and battery charge. So the grand jury did not find probable cause as to this very charge, which was the only charge anywhere in this entire record of this case that could ever be seen to support a 209A restraining order. So I would offer the docket and the 1-page grand jury proposing it under impoundment to show, support, and corroborate the defendant's testimony that this charge was never even sustained as to probable cause in the grand jury.
May I see the
Yes.
documents?
For the record, Judge, I'm giving you the Superior Court docket on this case that emanated out of this court with no assault and battery charge, and just the 1 page of the grand jury where he asked for the indictment.
All right, so I think the docket is relevant and will come in. The grand jury minutes are not coming in.
Yes, sir.
Thank you.
So the docket, any objection to the docket? No. Madam Plaintiff?
Sorry, I know you're.
Okay, that'll come in as exhibit number 6.
Will do, Your Honor.
And your motion to admit the grand jury minutes this time.
Thank you. That's all I have. Thank you. Defense counsel.
Any recross?
No, Your Honor.
All right, thank you, Mr. Kearney. You may step down. Attorney Bradl, any other witnesses?
No, Your Honor.
You rest at this
Thank
time?
you so much. Yep.
So this time, both parties have rested. We'll stop with counsel for the defendant. Attorney Bradl, I'll give you an opportunity to make a closing argument. The Madam Plaintiff, you'll get the last word, and I'll hear your closing argument as well. Thank you.
Judge, I appreciate the attention and the time you've given to this case. I'm not going to belabor the closing since it was the subject of your attention and scrutiny, as I saw. And I just want to say that there's no evidence here, Your Honor, that this plaintiff is reasonably in fear of imminent serious bodily harm. And more to the point, she's equivocating about being in fear of imminent serious bodily harm, where we see from her October 15th tweet, this is no shrinking flower. She is not afraid of Mr. Kearney in any respect. She's always been the aggressor in this relationship. She's the one that threatens people when things get tough on her. She lashes back out. She doesn't shrink away, Your Honor. She threatens people. She told Mr. Kearney that it was going to be the biggest regret of his life breaking up with her. I think the biggest regret of his life is probably going with her to begin with. And, you know, he's been suffering for this ever since. We have a very credible witness who came in here and told the court that, number one, the plaintiff recanted this bogus allegation, as minimal as it is, and as non-serious bodily harm as it is, that she recanted it. And she admitted to her that it didn't happen, and that once she kind of got that rock rolling down the mountain, that she wasn't going to change it, that she couldn't change it. And that is consistent with her character, or her lack of character, her abusive, threatening way that she treats anyone that crosses her. And she continued that with Ms. Bagwell when she tried to express her opinion about some of the dangerous behavior, self-harming behavior that the plaintiff got into. You know, she got threatened up and down all over the place. And that's what this plaintiff has shown herself here to be, is someone who is the aggressor, who threatens. And when the machine of the government's 209A framework is handed to her, she uses it as a weapon. The only abuse in this case is her abuse of our 209A system, which is incredibly important for legitimate victims of domestic violence. And she's done nothing but secure the benefits of that through lies. She uses it as a sword rather than a shield. She goes to where Mr. Kearney is. It's no different than if Mr. Kearney worked down the street at the Shell station in the garage, if she went down there to provoke him and antagonize him. She knows that Mr. Kearney is working the Karen Reed case. She developed this phony interest in the case only to antagonize and further torment Mr. Kearney. That's what the evidence here showed, Your Honor. It's high time that the court system, that Your Honor, the fact finder in this case, saw the case for what it is, which is nothing but a torture device for Mr. Kearney. He has never put his hands on her. He never did any of the underlying actions here. And that said, Judge, I think that's overwhelmingly what the evidence shows. But even if it was one of those scenarios where us lawyers kind of take the truth of the matter asserted and just look at it that way, which I hate to do, but let's do it. Getting pushed on a couch over a year ago does not warrant this order today and now. That's the sort of the secondary argument, Judge, that, you know, we don't need to go into what happened, what didn't happen. I think the evidence is overwhelming that it didn't happen. But even if it did happen, it's not something that ought to support another year of a restraining order where she's going to use it and use it consistently with the history she's already shown, how she uses it as a cudgel to torture Mr. Kearney, to make him have to leave the courtroom, make him have to run away from her all the time. She's not afraid of, you're not afraid of someone, Judge, when you go to where they are. You're not afraid of someone when you generate 3 inches of antagonistic tweets and Facebook posts or whatever it is, criticizing him, antagonizing him, making false charges against him. She's trying to engage with him. She's trying to provoke a violation. So, Judge, here I ask the court to conclude that this plaintiff has zero credibility in terms of being a supposed victim. She makes a mockery of being a victim. She reaches out and tries to destroy people. And I hope that this court, I have every confidence that this court sees the facts of this case for what it is. And I ask that you vacate this order. There's no need for this order. There's no danger. The only danger here has been to Mr. Kearney's mental health based on all of her actions. So I would ask that you vacate the order. Thank you.
Thank you, Attorney Bradl. Madam Plaintiff, this is your opportunity to make your closing whenever you're ready.
I want to reiterate that I am in constant imminent fear of the defendant. That is a fact. Attorney Bradl has no way of getting inside my head and knowing what I experience every day. I'm a single mother of 4 children, very young children, and they live in fear. I am scared every day of my life when I wake up and I have to leave my house or send them to school. I'm terrified that he'll show up to their school or recruit one of his crazy fans to do something on his behalf. I'm constantly looking over my shoulder, worried about being followed. I have been followed numerous times. I'm worried without this order, there's gonna come a day where he's gonna get desperate enough to do something that there's no coming back from. My children, their lives have been severely impacted. I have developed almost an agoraphobia where I'm afraid to go out with them and bring them to the park. The only trauma, they were never woken up that night. That all of that was just a bogus lie concocted by Mr. Kearney, and the only trauma they have is the trauma that they've seen as a result of what he's put me through, seeing their mother crying constantly because of the torment and harassment that he puts us through on a daily basis, posting my children's private probate documents and pictures of them online, and the threats, the phone calls, and I mean, I have panic attacks constantly. I'm in therapy. There's no doubt in my mind that if this restraining order is not renewed, he's going to ramp up his harassment, continue the stalking, and actually physically harm me to prevent me from testifying. He tried to prevent me from testifying and got the witness intimidation charges by bringing up private and probate documents from my past and threatening to publish those online and using his platform to do so. He has shown that his mental health is not stable. I don't know what he's capable of. I don't want to have to come back every year and face him, or I mean, I went to 2 hearings. I had involvement in or interest in the case long before I ever met him. That's how I met him, because he was covering the case and I bought a Karen Reed t-shirt. That is how I met him. This wasn't me seeking him out. Mr. Kearney has a history of doing this to multiple people. He has bragged about, I think he said, over 20 people trying to get orders on him and never once succeeding. And
Objection to argument outside the evidence, Your Honor.
It's outside the scope. Your objection is sustained. You may continue your argument, but not on that topic.
the order is not supposed to prevent me or stop me from living my life. And that's what he's been trying to make it do. I shouldn't have to stop the things that I'm interested in or not go to places. I mean, I lived in Dedham my whole life. I mean, this is where I grew up. He lives in Western Mass. He comes out here, out this way. There's no reason for him to be out here. The rape investigation also is still open. I was informed by the Medfield detective just 2 weeks ago. And he says he wants nothing to do with me. He posted about me just 2 or 3 days ago, I think it was. Still posts about me to this day. He's the one constantly provoking and harassing. This is about power and control with him, and I've seen him do this to other people, and I just want to be left alone. I want to be able to resume some normalcy for my children and I, and that'll never happen if this order is not renewed. If this order goes away, there is not a doubt in my mind that this man who is hell-bent, has admittedly stated that he's hell-bent on revenge, is going to try to concoct something just like he uses his fans as a tool to be able to do so. And I would just ask that and one more thing I just want to mention, the restraining order violation. He did the right thing at first, leaving the courtroom. If he had just left the area and left completely, he wouldn't have been charged. There's no way to set somebody up. If you see them and you leave the area, that's what you do. He made a conscious choice to stay in the area, hide. There's pictures of him in video, hiding in the bushes, following me as I walked to my car, filming me. I mean, he wrote a blog about me the next day using those pictures that he took. All he had to do was leave the area. I mean, there was nothing, the hearing was over at that point, and he made a conscious choice to stay. I just respectfully ask you, Your Honor, to extend this order and as the only means of trying to keep me and my children safe. That's all that I ask.
Thank you very much.
Thank you.
ma'am. All right, so I'm about to render my decision, but before I do, I just want to caution all in the gallery. I heard a couple noises and some disruption during these proceedings. And I'm going to warn you now, decorum will be maintained. I don't want to hear any outbursts. I don't want to hear negative or positive outbursts. Okay, decorum will be maintained out of respect for both the plaintiff and the defendant. So I've had an opportunity to consider the evidence that has been presented before me, and I have to consider whether or not I'm going to extend this order. I find that the plaintiff has not met her burden and that there is not a likelihood of further abuse, and the order will not be extended and will expire at 4 p.m. today. Thank you.
Thank you, Your Honor.
So yeah, that's the end. Thank you guys for donating to the Legal Defense Fund. Yesterday was Tuesday was an expensive day, you know, putting this whole thing on and fighting this. We won, you know, I'm glad that's over. You know, obviously wasn't the easiest thing for me to talk about publicly, but I'm glad that the judge saw through this and that I no longer have to live in fear of that. So thank you guys. And thank you to everybody who donated. The only ones I didn't get to put up there: Susan, Anonymous, Cosmic Blue, Paul, Blessed Mom from Texas, Spicy, Tech in Generic, Sherry Ann, Heather, Anonymous, Stephanie, holy cow, Stacy, Leona, CK, Wendy, Dina, Jeno, Danielle, Lois, and thank you to just everybody who donated. I really, really appreciate that. So I have court tomorrow in Dedham at 9 a.m. For the McAlbert thing. I'm sure she'll be there, but you're more than welcome to come. I'll be there at 9 o'clock sharp. I don't know what courtroom it's in, but tonight we're postponing Turtle Club till tomorrow night, like 10, because Notre Dame football is on. And here come the Irish. So love you guys. Thank you guys for everything. And we'll see you tomorrow night on Turtle Club. Peace, Turtle Riders.